Hello, everyone, and welcome. Thank you for joining us today for another Mobile Ecosystem Forum webinar. Today's title, Navigating Canada Digital Shift, the Bill C-22 and Beyond. My name is Dario Betti. I'm the CEO of MEF. If we don't know us, MEF, we are a global trade association for the mobile telecom ecosystem. So we are global, but we love to go deeper down into topics or sometimes countries like today. In fact, as you probably know, we are preparing our fourth Canadian Leadership Forum event for MEF, which will be in conjunction with Canada Telecom Associations on the 14th of July 2026 in Toronto. So come and join us if we can. But today, we don't need to just talk about the event. There's plenty of other things to talk about. We are no stranger to the Canadian market, but today's session comes at a critical moment, I would say, in the digital policy for Canada. And the world in our title, Navigating, is probably necessary. It might be the case. Companies involved in digital services might be a bit lost given how much of stuff regulatory and not only is happening in Canada. At the center of the debate is potentially Bill C-22 in the title. We'll hear more what it is, but that is pretty much triggering a significant discussion for government, but also for the industry and civil society. It provisions lawful access, metadata retention, and encryption as well. So pretty hot topics, each one of them. And it raises important questions to balance security, privacy, and innovation. No surprise, these are some of the traditional topics we cover here. But what really surprises, if this is not standalone, there is much more happening in Canada. And if you're a company in the middle of this, you're probably working out not just the abstract questions, what's the questions of these policies, it's more about how we're going to be managing our network, how we're going to design our services, how we're going to build compliance across these level of jurisdictions, Canada and across. So to look at Canada and broader, have a digital strategy in particular, we will talk about privacy, we'll talk about artificial intelligence, we'll talk about online harms, a lot more. And in order to do that, I'm very happy to say what we're doing with a leader in the field. We're pleased to be joined by Michael Geist, one of the leading voices in this space, who will help looking at the issues and provide a clear view on what's happening in Canada. Welcome, Michael.
Thanks so much for having me. Really nice to be here.
Well, if you are not Canadian, you might have not seen in the news or heard Michael before. Well, actually, his role is pretty international, but you might be at least partly excused. So here is a few pointers. Michael Geist is a leading authority, as I was saying, on digital policy, both on privacy and internet law in Canada. He's a professor of law at the University of Ottawa, where he held the Canada Research Chair in Internet and E-commerce, and is a member of the Centre for Law, Technology and Society. Michael is recognized for his work, as I've said, which intersects law, but also technology and public policy. And he has a strong focus on issues such as privacy, surveillance, and digital governance. You might have, as I said, heard or read about him as he's a contributor to major national media and the author of a widely read blog on internet and intellectual property law, as well as the host of Law Bites, one of Canada's leading technologies, law podcast and program. So you can hear more from him across. But today is all ours for this webinar. So, well, let's start. First of all, welcome again. And I'll give you the hot potato because starting right now, so much happening in Canada. Where to start? Can you give us a bit of an overview of the basic, what's happening in the framework for Canada digital policy and legislative agenda?
Yeah, no, thanks again for having me. And I think that's the right place to start because last number of weeks, recording this here, and that's towards the end of June. And I have to say that this month has been dizzying for anyone that follows the space. In fact, there was a 2-week period where just about it felt like everything was happening. And let me just kind of run through them. And I know that we'll have an opportunity to then break them down and get into a little bit more detail. It effectively started, in my view, very late in early June, late May, where the government announced that it was backtracking on what had been one of their cornerstones of their digital policy approach, and that had to do with requiring online streaming companies to make mandated contributions in support of film and television production in Canada. There had been a base contribution established a couple of years ago of 5% of their Canadian revenues. They then, our regulator, the CRTC, which regulates both broadcast, telecom, and now these internet services, expanded that to 15% with a series of different requirements, including mandated investment requirements and some additional contributions. And that started to really attract U.S. attention from a trade perspective and U.S. opposition as Canada moves into trade negotiations with the United States to renew its trade agreement with Canada, the U.S., and Mexico, led, I think, Canada to say they were going to backtrack altogether. And we are waiting for instructions to the regulator, basically to hit the reset button and start again. But the government has said that's what they want. I think in some ways that represented the end of an earlier era of digital policy. And then the government went full speed ahead over the following 2 weeks. And so it introduced its AI strategy later than they promised. They had said that it would be introduced toward the end of last year, but nevertheless, they put forward the AI strategy. A core part of that strategy, they said, was around trust. And they focused both on online safety as well as on privacy. They didn't include any details or significant details about what they had in mind, but within a matter of days, they introduced new legislation there too. So they introduced both what they call the Digital Safety Act or the Safe Social Media Act. The headline there, which we're seeing in some other countries, and including in Britain, is the notion of a social media ban, although some describe it as a soft ban. We can get into that as well, and that would be for those under the age of 16. It creates a new super regulator, a digital safety commission, which will have enormous powers on the digital safety issues and the compliance that'll be required. But we kind of underestimated in some ways just how powerful, because a few days later, government introduced the privacy side of the equation with new privacy reform legislation that not only sought to update Canadian privacy law, make some of the substantive provisions more closely aligned, I would say, with the European GDPR, but went further by actually removing responsibility for privacy regulation from the Privacy Commissioner of Canada to this same super regulator, to the same Digital Safety Commission, which will also have responsibility for private sector privacy. So we can get into that because that raises a whole series of issues as well, and there are timeline concerns. And then lastly, as if all that weren't enough, while this was taking place, the headline that we thought we'd be talking about here, Bill C-22, lawful access legislation, highly controversial, raising really significant amount of concerns, attracting a lot of attention, certainly from operators, companies, VPNs, messaging services, and the public as a whole. And the government pushed that through without the kind of debate that you would typically see at committee. They made some subtle changes, but there are a lot of concerns that remain, and managed to get that passed before they left for the summer. Now, that's passed in the House. It still has to go to the Senate. So there is still going to be room for more review and debate, but that's an awful lot in the span of a couple of weeks.
That's definitely an awful lot. One first question coming from outside of Canada, but what is driving this urgency to put so many things out there? Is it an intent to restructure the entire framework of law, or is it a certain sense of pressure from outside worlds? You mentioned the US.
Yeah. Yeah, that's a really interesting question. I think in some instances, certainly the decision to reverse on the streaming was, I think, largely being driven by pressure from the United States. I think it was also driven by a bit by concerns that the kind of numbers that were being proposed would have a material impact on investment in Canada. And so you've got a government that is, of course, highly sensitive to trying to attract investment. I think they had concerns that this might actually either result in reduced investment or a reallocation of some of the investment, and that would have some pretty significant impacts. So part of it is that external pressure. But part of it, I think, also is just the government having made commitments to saying they want to move ahead, position Canada to try to be a leader, or at least not a laggard when it comes to AI. And some of those other issues follow when it comes to the privacy or digital safety. And I think we've seen the government really look at what's happening in some other jurisdictions. Australia, of course, is providing the experiment with respect to the ban, but the DSA in Europe and similar kinds of rules being adopted in other places left Canada feeling that there was a need, at least in the minds of some, to move ahead with something. Lawful access, I wish I knew what was driving this. I mean, in some ways, this is a decades old debate. We've had law enforcement agencies seeking these kinds of powers for more than 20 years. And, they found, I think, initially when we had an election in Canada a year ago and a replacement of our prime minister moving from Justin Trudeau, who was in power for a very long time, to Mark Carney, I think the law enforcement side saw an opportunity there, a new prime minister, a new opportunity to introduce something. And in fact, they found a ready audience because Carney and his government included lawful access provisions in quite literally the very first substantive bill they introduced just over a year ago. But it received an enormous amount of backlash, and so they withdrew those elements from the bill, said that they would consult and reconfigure the legislation. They did in parts, but they left a whole series of other provisions in place, actually added some as well, around, for example, mandatory metadata retention. And the effect really was to create a whole new controversy. I guess one last thing, as I talk and think about it, I mean, in part, some of this is a government trying to frame a lot of this, or at least sell these policies as protecting kids online. I mean, that's has tended to be the focus, and so they have tried to do that in this context as well when it comes to lawful access. I think somewhat implausibly arguing that kids in danger may require mandatory backdoors and the ability to break encryption.
So let's talk about this bill, which is also referred as C-22, or
Yes.
lawful access and encryption. I mean, you highlighted some of what it is, but to make it more tangible for, let's say, a business, a technology provider, somebody involved in telecommunication, digital services,
Yeah.
what would be the core provisions? What would be the impact today of Bill C-22?
Sure. So, and again, with the caveat that the bill has now passed the House, but is still headed to the Senate. And in Canada, bills have to receive approval from both houses. So this is something that is at this stage, I would say, unlikely to take effect before the end of the year. I think it's reasonable to expect that we'll see the Senate engage in its own study of this bill through the fall, and then we'll see what happens. But this is something probably to put on people's calendar for taking effect into 2027. And I guess I should start by saying I wish I had a good answer about the specifics. But part of the problem here is that the government has punted, has left for another day, future regulations and the like, some of the specifics. So we do know, for example, that they are going to regulate what they call core providers, and they reserve the right and actually include some regulations for a broader category of electronic service providers. So electronic service providers, or ESPs, would be that whole universe of electronic service providers. That would include online messaging services. It would even include device manufacturers. I mean, in theory, initially, it could really target a very, very broad scope of providers, almost anyone providing some sort of service in a digital realm. But core providers, I think, are generally understood, or at least expected to be, more traditional telecommunications companies, providing physical infrastructure. But we don't know for sure. It's always certainly open to the government to play with those categories a little bit. Regardless, they've reserved the right to flexibly apply these rules really to that entire universe. There are different safeguards in place, but by and large, anybody could be targeted. And I guess I would say there are, from a big bucket perspective, at least three things to be thinking about here. The first is cooperation with law enforcement during investigations in terms of seeking access to subscriber or user information. Early efforts at this legislation envisioned requiring providers potentially to provide certain information without even court oversight or a court order. And I think there were many, myself included, that argued that that was inconsistent with certainly Supreme Court of Canada jurisprudence. It talks about a reasonable expectation of privacy that subscribers have, even in basic subscriber information. And so they withdrew from that. That was really where the big change went, and have created a framework that allows for a number of different mechanisms depending on that escalates in terms of the kind of oversight or standards that are needed depending on the sensitivity of the information. So at one end of the spectrum, they are introducing a new power, which would be a confirmation of service demand power, which would allow law enforcement to go to a service provider and based on just on reasonable suspicion, which would be our lowest standard, the ability to say, is this person a subscriber? And no court oversight, simply the ability to demand information as to whether or not this person is a user or a subscriber. Law enforcement has long argued that it can be a time-consuming, arduous process to obtain the necessary production orders or retention orders for information. And so they argue this allows them to have an assurance that if they're going to go through that process, at least they know they're targeting the right provider. There's a second level then, which is new, which would target basic subscriber information. And so this would include things like the name, address, IP addresses, services that are used, all stuff certainly beyond what the government at times likes to call phone book information. But nevertheless, not the content of messages, but much of the other information around it. So it's kind of metadata plus in some ways. And that would be obtainable with court oversight, but with a lower standard of reason to suspect. Then there is a third level, which we've had in place for some time, which would speak to things like production orders or retention orders, and that has that higher standard of reason to believe, which would be the highest standard that they'd have to assure themselves beyond just some suspicion. So there is a whole framework that certainly many of your members and others may find themselves subject to when being required to cooperate with law enforcement. There is then a second element that becomes, I think, quite important, where we get into the cooperation, not in a particular investigation, but really more broadly. It essentially tries to establish the necessary framework to give law enforcement, and we're talking law enforcement here, it's not just local police, it's national police forces, it's intelligence agencies, signals intelligence. It covers a pretty broad range of providers or of people engaged in national security and law enforcement. And there's at least a couple of things worth talking about here. One, and we can get into it, is the mandatory metadata retention, which is new for Canada, attracted a lot of attention. And the other speaks to a whole basket of requirements to essentially work directly with these agencies, if you're a provider, to ensure that they have they have access. It's often described as backdoor access, but access within the network itself, better familiarity about who's involved, potentially access to encrypted information. And so that's where we've seen, both on those latter two, where we've seen a real outcry, I think, from many different providers.
When you speak about metadata, sometimes people will say, well, metadata, it seems very okay. It's not your data, but what kind of examples of what is metadata in these specifics? What are we looking at from a real use case?
Yeah, so metadata is, of course, just data about data. But from my perspective, it creates essentially a surveillance map, allowing law enforcement to go back in time to identify where users were located, who they were communicating with, how long they communicated, what they communicated with. I mean, a whole series of bits of information that may not give them access to what was actually said during a conversation or communicated in a message, but with everything else around that data, that in some ways may be more valuable in terms of knowing if someone's there. And the kind of use case that law enforcement has provided for mandatory metadata retention really speaks exactly to this. So, as an example, they've highlighted a circumstance where they say, well, what if there's a violent incident, let's say a shooting in a Canadian city? They would like to know who was around, what bystanders may have been there, may have seen something, may have been involved themselves. And so they believe that mandatory metadata retention would allow them to piece together a map of people in a particular area at a given moment in time, and the ability to go back in time to do that. And so the metadata retention would, for anyone with, of course, a mobile device connected to a network, they'd be in contact with a tower in the area, and they would know really when they arrived, when they communicated first with that tower, when they left, who they communicated with, a whole range of different things at that moment. Now, law enforcement sees that as a feature. I would say that privacy people see that as a bug, because they really are talking about the prospect of constructing that kind of surveillance map on a retroactive basis, right? So you don't know at that given moment. This isn't real-time surveillance. This is surveillance that essentially allows you to go back in time to identify uh, what took place or who was around at a given moment. And I think the concerns there in terms of the lack of protections that exist, the fact that you're collecting massive amounts of data or being required to retain massive amounts of data, no real business use case for it. It's being done purely because law enforcement or the law requires it. And I think it's fair to say that for 99.9% of that data, you're talking about people who have done nothing wrong, have no reason to be monitored, and yet the system captures everyone. It is building a massive haystack in the hope that you might need a needle at one point in time. And, initially the government proposed that this would be required for a year. So a year's worth of metadata retention. They then in that last moment when they were going through the amendment process, cut that in half to 6 months. In fairness, they also said that they would identify specific categories of metadata that would be retained. But we can pretty much surmise what those categories will be. And the fact that they moved from a year to 6 months, it's just because there was this kind of political pressure, I guess, really highlights the disconnect between the policy and the evidence for the policy, right? I mean, if on Monday you thought you needed a year's worth of this data, and on Tuesday suddenly 6 months is perfectly okay, I think that tells us that in fact they haven't really done the hard work of demonstrating where there's a need. And I'll close with this. The reality is Canadian law, like many jurisdictions, provide the ability for law enforcement to obtain orders that would require providers to quick freeze, so to speak, the information so that they would be required to retain the information. You've got it. You've got an investigation. You've got a suspect. You've got other potential suspects. You meet the necessary standard, and you want this data retained on an active basis as part of your investigation. Well, that clearly exists right now, and it is obviously much more targeted in terms of the information that's being retained. The question is, how long do you need to have this metadata retained, if at all, in order to be able to kickstart this process where you are now getting the targeted information for the specific law enforcement targets? Is it 30 days enough? If you've got an investigation by that time, are you then able to say, all right, we need this data retained? Is it 60 days? Is it a week? Is it in fact the case that the quick freeze is sufficient? Those are the kinds of questions I think we ought to be asking. There are real costs to the providers. There are real costs to users as well. And just because it makes it easier for law enforcement isn't, I don't think, enough of a reason to move ahead with the policy as currently contemplated.
Interesting. Well, let me add some more speculations if we've needed any more. I don't think, but we have some of our companies here listening today that might be international companies. Telecoms is a very borderless examples of a network. So how does these interact with cross-border data flows and obligations under other regimes, such as GDPR, for instance? Does that apply?
Yeah, I mean, the GDPR issue is an interesting one because I think that, especially if we combine the lawful access with the privacy reforms that I mentioned off the top, I think there are real questions, especially with the structure they've created, as to whether or not Canada would continue to qualify for the adequacy finding that it currently has. Now, it may well be that there's a political dimension there and nothing changes. But I think some of the questions, especially around removing some of the powers of the privacy commissioner to an enforcement body and a commission, which is less independent of government, I think creates certain risks in terms of how we stand with others. In terms of what we see globally, you're right. In some ways, that's what the Canadian government often likes to point to. So they like to say, well, listen, look at our Five Eyes partners. They're doing the same kinds of things. Canada is a laggard in this regard, and so we need to catch up. The problem is it's not really true. And so the approaches we see, let's say on metadata, vary dramatically between jurisdictions. And so you've got, let's say, Australia at one end, which does have lengthy mandatory metadata retention periods, although the implementation of that has resulted in real concerns about potential misuse and abuse of some of that data. Um, you've got other jurisdictions in the United States that does not have metadata retention requirements at all. And so it's pretty clear that on a domestic level, there is nothing strictly requiring this. But nevertheless, government is moving ahead. There are other elements there that I think some have pointed to and they are of the view that part of this is setting Canada up for future agreements. I mean, you're right to focus on the international dimension. For example, the second additional protocol to the Budapest convention that deals specifically with cyber crime. This is seen as potentially helping to facilitate that. There's the U.S. Cloud Act and the prospect that some of this could play into that in terms of active cooperation. So, I think it is fair to say that there's certainly some within government that look at this and their eyes are on sort of future agreements or agreements that are already in place that they'd like to see Canada become a more active participant in. But the government, by and large, has not sought to rely on certainly those agreements, though they do try to use the comparator argument quite frequently to say that, Canadians have nothing to worry about here. This is just what everybody else is doing. Their problem is that really just isn't true.
So you have just mentioned right now the private sector privacy reform, which I think is one of those multiple things you're piling up at the beginning and say all of it is happening at the same time. So
Yeah.
where is that going in more details? What path are we looking Canada taking on privacy?
Yeah, great question. And in some way, listen, it's early days. Legislation was just introduced in the last week or so, and it is at the very beginning of a process. It feels as if the government was hoping to put both the privacy bill as well as that social media regulation bill kind of in the window and give the summer for people to provide feedback or react, and then assume the government will push the accelerator come the fall. In some ways, I think this privacy bill is a tale of two bills. There is the part of the bill that is by and large focused with modernizing Canadian privacy law, making it more consistent with what we see in other jurisdictions, of course, most notably Europe with the GDPR. For those that don't know, Canada first introduced private sector privacy legislation back in the late 1990s. This current bill has been in place since the year 2000, so more than 25 years old at this stage. And while it may have been fit for purpose when it was first introduced, I think there is broad consensus that it has been in bad need of updating. And in fact, this is really at least the third time the government has made an effort to try to update this legislation. And over the years, there were different, more isolated reforms that were in fact enacted: anti-spam legislation, mandatory security breach disclosure requirement. So there've been little piecemeal things that have been adopted over the years, but sort of a more comprehensive change to Canadian privacy law has been a long time coming. And on that front, I think many of the kinds of additions or changes to Canada's rules will look familiar to an international audience because they do borrow certainly from what we see in some other jurisdictions: data mobility rights, right to be forgotten types of rights, stronger penalties that are premised on both order making power and the prospect of a certain percentage of revenues. And so in that sense, a lot of that stuff will look, I think, generally familiar when contrasted with others. The Canadian environment's a little complex. We have provinces that have their own sets of privacy laws. They're designed to be able to coexist. And so there will always be some amount of questions, but for telecom providers, they're largely captured by the federal legislation in any event. And so the element of the legislation that focuses specifically on sort of the substantive privacy rules, as I say, they'll be generally familiar. I mean, there are some newer issues that have really come to the fore that are challenging, AI in particular driving some of those. So the power of AI inference and what that means for de-identification or more aptly, re-identification of data and some of the challenges there. They've tried to tackle some of those kinds of issues, to be sure. And so I think there can be a really robust debate about some of those provisions. And generally, we probably would have a pretty reasonable landing spot for it. But there's a second element to the bill, and that speaks to the government's decision that they felt that privacy law at the federal level in Canada needed stronger penalties and needed essentially order-making power. Our current commissioner is an ombudsman plus type approach where They can issue findings, but they're non-binding. They need a court to actually enforce what they would like to see happen. And so you end up with these court cases. And they have limited powers, no real powers of penalties other than failure to cooperate with investigations as opposed to failure to cooperate with findings. And so there's a consensus that that is needed. But interestingly, the Canadian government is very reluctant to give those powers to the Federal Privacy Commissioner, in part because the Federal Privacy Commissioner in Canada is an agent of Parliament and is more independent of the government. Now, there are many who would say that's a great thing. That's what you want. You want someone focused on these issues to be immune from some of these government pressures. But notably, the government doesn't seem to agree. And so they propose to transfer all responsibility for private sector privacy legislation from the Federal Privacy Commissioner to this new Digital Safety Commission, which will actually be renamed to include the privacy piece of this as well. That has a couple of effects. I think it really eviscerates the strength of the Privacy Commissioner. The majority of its people and the majority of its role over the last couple of decades is on private sector side, and so that will be gone. So it's hard to know what will be left of the Canadian Privacy Commissioner once that's completed. It also vests massive power in the hands of this new super regulator. Canada would be the only country that I can find that would combine sort of the online safety piece that we do see in many countries with the data protection or the privacy piece. That's an awful lot of power to vest in a single entity. And it also means that this will take a very long time to get up and running. And there's a bit of a disconnect here where the government talks about privacy being a top priority, that need to move quickly to address these issues. But the reality is it is going to take years to stand up an entirely new commission, establish all the regulations, directives that are associated with sort of their governance, and then move responsibility for something as big as privacy all the way onto this new entity.
You just mentioned it in your answer, but I think I'd like to go back to one of the topics, which for me is one of the things I have to keep on reminding myself when I look at your cousins on the south border. If we look at the US, it is a federal law, but is also a lot of state law, and then courts are important. If I look at Canada, how important is these dynamics that you mentioned between provinces and state law? Are we going to see some major surprises, or are things pretty harmonized?
Yeah, so the federal law requires that the provincial laws be substantially similar. And there's a process for that kind of designation as to whether or not they are substantially similar. At the moment, there are really three provinces that have broadly applicable privacy laws within the province. That would be Quebec, provinces of Alberta and British Columbia on the west coast of Canada. I would say that Quebec, as in many things in Canada, is the outlier here. They have private sector privacy laws that predate the federal law in Canada. So they've been active on this issue. They have brought forward legislation that is much more GDPR-like and has been in place for some time. So they would say they are waiting for the federal government to catch up to where they already are. In the other provinces, they've been more consistent, and their approaches are quite similar, more consistent with what the federal system is required, and so they might actually then need to make changes to their rules as well. There are quite a number of other provinces that have narrower privacy rules, particularly in the health field. So there may be health privacy legislation. So the province has asserted jurisdiction over a more narrow part of privacy, but there are other elements that effectively get left to the federal commissioner. And so it is a bit of a hodgepodge, so to speak, and can create some amount of confusion. And in fact, even in provinces that do have that broad private sector privacy law, that applies sort of internally. But once you end up with activities that cross provincial lines, then the federal law kicks in again. So for the purposes of people watching this, many of the telecom providers, of course, are going to fall into that latter category where they are operating, of course, across provincial lines in many instances. And when they do, federal law, once again, is what governs. And in fact, those that fall within federal regulation are also themselves covered by the federal law by virtue of the fact that they're federally regulated, and telecommunications companies that are regulated are there too. So the starting question, there's a tendency to jump into what are the requirements and how do I get consent and what powers does the regulator have? In some ways, you've put your finger on what really is the starting question, which is, okay, which rules govern? And am I having to comply here with multiple sets of rules along the way?
Very true. I couldn't stop the debate here without mentioning AI, and especially in a week, we've heard, well, we've seen positioning. The US has been blocking experts and blocking internal usage. The European Union has said we need a sovereignty policy on top of our framework. India has been doing something completely different. Where is Canada? What's happening with the AI rules?
Yeah, no, that's a great question. And, it depends a little bit who you ask, because there are some who will try to tell you that Canada is trying to come up with robust AI rules and perhaps following a EU model or early EU model. And we've seen a bit of a shift more recently away from some of that. And so I guess I would characterize it this way. Canada's early efforts at AI regulation, which were actually made together with the privacy reform that ultimately failed, largely just said, okay, the EU AI Act looks fine, let's just take that. And it provided it in a sort of bare bones way with many of the details to come. I think many were left unsatisfied with that. They felt that the government hadn't adequately consulted or really kind of figured out precisely what it had in mind. And so when it came time to coming back with something, this privacy bill, as we've talked about, does not include that element at all. Once we had a new government in place, they tried to signal AI was a priority. We have an AI minister for the first time, Evan Solomon. And his initial comments were that Canada may have over-indexed on AI regulation, which was taken to mean that he felt that there was too much emphasis on the regulatory piece and not enough on the innovative side of AI and adoption. They've tried to essentially manage that and sort of those competing objectives. And of course, it's not easy to do. I would say the AI strategy falls more on the side of adoption and use than it does on regulation. And so in that sense, becomes a bit more like a US style approach. Not entirely, because there are rules of the road, but I think there is a lot of sensitivity that, especially if you're a country like Canada that is literally right next to the United States, where our companies are often competing in the same markets, not just for customers, but often for employees who can, developers and others who can easily cross the border, usually, and move between companies. That creates a situation where you've got to be cognizant of your competitiveness. And so there's been a real focus on adoption with government support on it. There is also, and I think this is true in a lot of countries, been a lot of support on AI sovereignty and digital sovereignty, and certainly the issues that have arisen in the context of Anthropic's mythos sort of highlight some of that. But there's elements there not just on sort of the AI companies, but also on the data itself and whether it remains sovereign. So that's led to some emphasis on creating Canadian infrastructure, whether that's cloud-based infrastructure, AI infrastructure at home. But there are limits. There are limits, of course, of the availability of some of the chips and other technologies that are needed, and those are often going to be foreign produced by foreign companies. And then there are legal limitations there as well, such as the Cloud Act, which may ultimately say even if you've got data, let's say, that is located in Canada, doesn't really matter so long as the entity that has control over it is subject to US laws. And that's not just the large US companies, that can be smaller companies as well that have some sort of footprint or connection to the United States. Now, I think that's true for many, many countries. In fact, there's a Canadian decision from last fall that involved a French-based cloud provider that had a presence in Canada with data located in France. And the Canadian court said, well, no, you need to hand that over. You've got a presence in Canada and you're subject to it. So Canada doesn't have a Cloud Act, but it has courts that are willing to assert similar kinds of jurisdictions. And I suspect that's true for many countries. So this is an issue that is still being sorted out. And, I guess to kind of bring full circle with your question on where do we stand with a government that's trying to achieve all of these kinds of objectives. And so that means there's a lot of balls in the air, but it's pretty hard to, on the one hand, meet the desires of some for stronger safeguards, while at the same time ensuring that you've got a country in a marketplace that becomes a leader in adoption or a leader in use or a leader in kind of building some of these technologies and companies. Because, there's going to be a tendency for many of those companies to shop around in a sense and look for the jurisdictions that are friendliest when it comes to potential investment and development.
Well, great. So we're going to look at these not just in Canada, but across the scope, across the world of how AI regulation develops.
Yeah.
But time to put you actually on a seat in the board. We keep on saying at MEF that regulation and compliance should have a voice at board level, should be listened to. If that's true, if you were a CEO, if you were a chief compliance officer for a company, one of our members in telecom and digital services, what message would you bring forward? What should they be looking or being considering right now?
Yeah. I mean, I guess there's two. There's the specific compliance related issues in Canada. And then there's what do these kinds of rules mean more broadly for your organization on a global level? And so I'll start the first part is simply if you've got Canadian operations, if you are considering having Canadian operations, even if you don't have Canadian operations, but you've got Canadian customers, the stuff we've been talking about matters. It is likely to touch on you in different ways. It is a bit of a moving target. And we have a government that is, at least for now, still sensitive to the potential reaction of various companies in terms of what it might mean for investment or operations in the country and the like. So there is an opportunity to have some amount of influence and impact here. So I would say not only pay attention, but potentially get involved as well, because I think that the moment is now, over especially in 2026, to at least ensure that Canadian legislators and policymakers have an understanding of what these laws might mean for you. So part of that means understanding the laws, then mapping it onto your own operations to identify what will that mean, and then thinking about, is there value in adopting a position on an individual basis or using associations and organizations that may speak on your behalf. So part of it is thinking about Canada per se. But I would also say that we're in a globalized world, obviously, when it comes to these issues. And the ability for individual countries to influence what policy measures look like and laws look like in other jurisdictions can't be underestimated. For years, we've been talking about the Brussels effect and the desire of European regulators to very quickly establish standards that then get adopted by others and have essentially at a minimum soft influence, but oftentimes even harder influence when it comes to what those regulatory frameworks look like. And of course, the GDPR is in some ways the poster child for that. The EU AI Act is an example of what happens when it doesn't totally work, quite frankly, when other countries look at it and sort of move away or feel that there are enough other pressures that it doesn't attract that interest. But I think that especially as I look at it from where I'm sitting here in Canada, we are seeing a number of countries vie for similar kinds of influence. There is now the Adelaide influence, or the Australian influence, no matter how you want to look at it. It gets described in a number of different ways, or the Canberra influence, Sydney influence, whatever kind of city you want to pick, because it's pretty clear that Australian policy is having a significant impact in other jurisdictions. That's certainly true when it comes to the social media ban, where everyone is pointing to its first mover approach, and they start thinking about, well, what does that mean in terms of potentially adopting it? But we see it in other places too. We saw it with respect to news and requirements for platforms to pay, and we see it with other forms of regulation. And so that Australian model is being used by others, and I mentioned in the lawful access context with metadata as well. I think there's a Singapore effect too, where Singapore has really tried to adopt leadership positions, especially around digital policy. We see it with the DEPA, sort of the first major digital economy partnership agreement that focuses on cross-border digital issues that does not include the United States. And so you see Singapore seeking to become a leader there as well. Now, I'm not saying that Canada is going to become a leader in here. We've had a tendency on issues to be a follower rather than a leader on some of these things. But as we look at some of the more innovative things or different approaches, for example, on social media bans and the soft ban approach that Canada has, what starts in Canada may not stop in Canada. And I think that's true for a number of countries. And that's why I think it becomes so essential for organizations who operate globally to be paying attention locally. And so I think you're right when you talk about the need to escalate the attention that is paid to some of these issues, because I think we're seeing that impact move rapidly across borders.
Well, you've mentioned, let's say, the Canberra or the Singapore, the Brussels effect. Um, is there a Chinese effect somewhere? Is there a Beijing effect?
Oh, just go to Africa and you can see it in operation. Absolutely. And in some ways, some of what we see is a counterpart to that, of course, right? Where we see responses to what's taking place, or at a minimum, it sits there hovering in the background with a recognition that they are the dominant player. I mean, there are many when you talk to people in the AI space who I say who look at the role that, frankly, Canada and Europe play in all of this and reach and sort of say, aren't we just bit players in a battle between the United States and China as part of all of this? And um, it highlights just how fast moving this is, how much capital is required, and given how quickly it moves, some of the challenges that exist. Canada, from an AI perspective, the one Canadian company that was held up as an example was Cohere, as a leading AI company that would potentially compete with some of the larger players. It recently merged with a major German player. Um, Still, it's pretty clear that the Canadian side is the sort of the big brother in that merger, so to speak. But it highlights why playing in this sandbox at global scale requires capital, requires personnel, requires markets that make it very difficult to compete with the two biggest established players in this space.
Before I went on a different path, I was asking you to play a bit of role game, becoming a CEO or chief compliance officer. Let me go back and offer you another role. What if you were redesigning the Canadian Digital Service legal framework? What if you were a legislator in the government? What would you do right now? What would you differently, I should probably say?
Yeah, no, that's an even funner one in some ways for me. Um, and I guess I would say it depends a little bit on the issue. I think at a minimum, we need a coherent policy. My frustration with some of what we've seen is I think there's a lot of incoherence. This feels a lot like improv, where government's moving very quickly. I'm not sure that there is a full, clear strategy on what's taking place. And so part of it is to start saying, okay, what exactly are we trying to achieve here? And then are the policies that we're putting forward actually going to achieve them? And I think there are good examples of how they're not. So, I think everyone can get behind, for example, in the social media, internet services world, the need for people to feel safe. Evidence to date suggests that a ban doesn't work. And even Canada's more somewhat innovative approach of a soft ban, where there's the ability to get an exemption, has it backwards, because the way, if you were going to do that, to try to create incentives, create safe spaces, would be to say, we're going to set the standard for what it means to have a safe space. If you fail to comply, we're going to have a series of powers in place. And one of them may be requiring you to go out and age verify your users and then block those users that are not of a certain age. Well, that's costly for the platform, and that will drive users away. So there's a real incentive there to ensure that you are compliant. We're doing the opposite. We're saying we're going to require you to age verify and ban off the top, and then afterwards you can ask for an exemption. It just doesn't make any sense. On the privacy side, if privacy really is urgent, and I do think it is urgent, both for an AI strategy and more broadly, then I would say, even if there is reticence about the privacy commissioner having these kinds of powers, which I must admit, I don't think there ought to be, but even if there was, I would say start with the laws, get them in place so that so that companies have the kind of certainty and visibility where things are headed, and then allow us to build in the kind of new regulatory infrastructure that we think will be more effective in the 2030s and beyond. And so part of this is, can we just at least start making sense in terms of some of the policies that we have? And if these are priorities, sort of make it clear that that's in fact reflected in the sorts of policies we adopt.
Perfect. And the more we talk, the more questions we have. But we had an incredible amount to start with. I think we went slightly over what we thought it was going to be the original timing. Anyway, All worth it. And you will hear if you just join us later, everything is available for you on our own demand service. Come back on mef.mobi to hear more from us. But for today, this is all we have for this incredible webinar on navigating Canada's digital shift, the Bill C-22, and as we heard, much more actually happening in Canada. A big thank you to Michael Geist, the Canada Research Chair in Internet and E-commerce Law at the University of Ottawa. Michael, thank you again.
Well, thanks for having me.
And thank you, and we'll be here with you again on another Thursday, on another webinar. Stay with us.